Hey, good morning. Welcome to Employment Hour in 30. I'm John Scholes. This is Lior Samfiru, and we are talking employment law. I will give it to you now. The phone number to get a hold of Lior and his team anytime when we're not on the air, 1-855-821-5900. There's email address as well, and that is help@employmentlawyer.ca. See, we changed that recently, like, I don't know, 6 months ago, and I still trip over it. So. I'm all over it. We talk employment law here, severance, workplace rights. Your boss, maybe you are the boss, maybe it's a wrongful dismissal, could be harassment. There's a ton of things to talk about every week on the show, so we'll get right into it. And later on, we're going to talk about the costly decisions that employers make, so you'll want to stick around for that. Severance Pay Calculator. I know we love this tool. We'll get into some depth a little later on in the show in that regard. But we always start, Lior, with a little segment we call The Week That Was, something that's been happening either currently or in recent history at the firm, and I know you want to talk about it.
I do, absolutely, and it's really a great opportunity to be back here and to talk about the employment law and workplace rights. In terms of the week that was, I spoke with a lot of people this week, emailed with a lot of people that asked me questions about their workplace rights, people that watched our show last week, the week before, and wanted to know how does the law apply to them, how does what we talk about influence them. So that's great, and I encourage everyone watching us right now to give me a call. Let's talk about your workplace rights. Let's talk about the problems that you're having, because I assure you, there's no problem that cannot be solved. If you're dealing with a workplace problem, there's a solution to that problem. You may not know what it is right now, you may not see it, but there's a solution, so call me. And to start us off, John, a situation that came across my desk, when we talked about this before, but I really want to emphasize this. I spoke with a lady that found out a few weeks back that she's being laid off temporarily. And the company said, we're a bit slower, we're going to lay you off temporarily, and our hope is to call you back in 3 to 4 months. Not for sure, but hopefully end of summer, early fall, somewhere at that point, we're going to want to call you back. Well, she was obviously very distraught by that because she needs this income. And there was never a guarantee about her being called back to work. And the company assured her that what they're doing is very legal. Well, someone that she knows watched us on the TV show, and she called me. Nice. And she wanted to know, well, Lior, is this actually legal? Can they lay me off temporarily? Do I have to stay at home for a few months hoping and praying for the best, or do I have other options? Well, John, this is important because I want everyone to understand that an employer generally does not have a right to lay off temporarily. A layoff, a temporary layoff, is a termination. If I told you that I'm reducing your pay by 50%, you would not argue with me that that's wrong. You can't do that. But what is a temporary layoff? I'm reducing your pay by 100%, by all of it. So that's clearly wrong. That's a termination. So what does that mean? This lady now has an option. She can, if she chooses, sit at home, wait for the company to call her back, hope and pray that that works out. Or she can say, no, I'm going to treat this as a termination. I am going to get my severance right now, and I'm going to move on to a different job. Now, she'd been with the company for a while, somewhere around 10 years. She could be owed as much as a year's severance, a year's pay. So that's what's at stake. And it's so important to do this, John, because if you don't treat this as a termination, if you sit at home, if you let the company do this, you've then given them the right to do it again. And the next time they do it, you can't do anything about it. Right. So here's the situation. You go back to work, you work for a few months, you get laid off for a few months, and round we go. That's no way to work. That's no way to live. So if your employer is going to start laying you off temporarily, you want to do something about it then, call me before you do anything, but you do have rights, you do have entitlements.
EmploymentHourTV.ca is a good place to go if you want to find out, among other things, where we do our weekly radio show that we've been doing for over half a decade now. And on the show, of course, it's radio. We take a ton of phone calls. We like to play some of them on this show and get some feedback, so we'll get to a call.
I just got notification last week that at the end of the year, I have to relocate from my Etobicoke office to an office in Burlington. And I've been with the company for 26 years, and I'm 55.
Yeah, well, obviously it's a big deal if you're going to be relocating, and certainly for those that are not familiar with those particular towns. I mean, that could be a hike. That could be another half hour, 45 minutes, depending on traffic each way. So if you look at it in terms of a day, a week, a month, that's going to add a lot of time to someone's commute. Now, generally speaking, when a change like that happens, when it's a significant change, it results in what we call a constructive dismissal. A company, even if it has good intentions and good reasons, does not have a right to make significant changes to the terms of employment. Oftentimes that means they can't reduce your pay, they can't demote you. But it also means they can't relocate you to the point that now your job is different. Now your time spent is that much more to get to work. If they do that, you have an option to treat this as a constructive dismissal. So that's her option here. If if in fact, depending on where she lives and how much this is going to impact her commute, how much more time it's going to add to her day, well, she could treat that as a constructive dismissal and say, no, I'm not going to accept this. I am going to treat my employment as being terminated and get severance. Well, of course, then the question becomes how much severance. So what she can do, what everyone can do, you go to severancepaycalculator.com to find out how much you're owed, whether it's a constructive dismissal or a regular dismissal. So let's take that information and plug that into our friendly severance pay calculator. So 26 years of service, she's 55. I picked the position, let's say she's in a clerical position. Well, someone in her situation, anywhere from 18 to 24 months of severance. 18 to 24 months. And that, by the way, that's months, not weeks, not days, it's months. So her options are, therefore, John, she can accept this relocation and start commuting to the new place, or no, she can say, I'm not accepting that, I'm going to leave and make you pay me that 18 to 24 months of severance.
Does the same thing apply with this situation that it did with the temporary layoff? That is, okay, fine, I'll move, and then she finds out 6 months later, I don't like this. Well, now she can't. They decided to move her again, Mississauga, Hamilton, so on and so forth. Can't she do anything about it?
Yeah, once she starts doing it, she's accepted it. And once she's accepted, number one, you can't go back. You can't say, 6 months ago when you moved me, I didn't like it, now I want my severance. It's too late then. And beyond that, if you've let them do it, you've given them the right to do it again. So you do have the ability, especially with the move, to try it out. I don't know how that's going to impact me. Is it going to be a big deal or not? So I'm going to try it. Usually that's only for a short period of time, a couple of weeks maybe, and with telling the company that that's what you're doing.
In writing.
In writing, because if it's not in writing, it doesn't exist.
Exactly.
So tell them, I'm going to try it out. Then you can, and then if you still realize, no, it's not working out for me, you can still treat that as a constructive dismissal. But the lesson, the important factor to remember is a relocation that impacts you is a constructive dismissal.
Again, it sounds familiar. Want to contact Lior and the team, 1-855-821-5900. Again, employmenthourtv.ca. You want to find a list of radio stations where you can catch our weekly radio show. The phone call was good. Let's get to a second call.
I have a health clinic, and all of the people that work with me are independent contractors. And I would just like to know what my rights are in regards to, or the law, in regards to when one of them is smoking and we've had patients complain and it's affected the business.
Sure. Well, interesting question. Now, the first thing, that's not what she's calling to ask, is I want to actually know whether the people that work for her are really independent contractors. Yeah. And again, I don't know anything about the situation, but I bet money on the fact that they're not, that in the eyes of the law, they are employees. And remember, for those watching us for the first time, it doesn't matter what you call yourself or what someone else calls you. If you have a regular job, you go to work in the office, you are an employee. Maybe you're calling yourself an independent contractor, it doesn't matter. Maybe you're paying your taxes as an independent contractor, it doesn't matter. You're an employee. But beyond that, she has a question, people are smoking and it impacts her clients, her patients, etc. Well, what she needs to do is very simple. She needs to make it clear in writing to these folks that you can't do that. Set out those expectations in writing. You're expected, if you're taking a smoke break, to come back not smelling of smoke. There should be no signs of you smoking. Put that in there. And if they still don't do that, give them another warning, and then potentially a third warning. And after that, you may be in a position to terminate their position, whether they're employees or contractors. So it's not enough to say, well, I told you. I want it to be in writing. There needs to be a written record of that. She's allowed to set those rules. They're reasonable rules. And even though smoking itself is legal, of course, an employer does not have to tolerate smoke or smell or odors in the workplace. She can decide that that's inappropriate and discipline if those folks are not complying with it.
Email address is simple too. Anytime, help@employmentlawyer.ca is the way you want to get a hold of Lior. And again, severancepaycalculator.com. Find out anytime what the correct amount of severance in your case should be. Always use that even before the phone call. Check it out. Then you can call Lior and his team to carry on. I mentioned off the top of the show we're going to get into a topic for today, and that is it's going to cost an employer if they let go of an employee for these following reasons. I'll start naming them off and you can expand on them. First one is when the employee suffers or may be suffering from a disability.
John, so we're going to talk about that and a few of those examples. But here's the thing. It's always going to cost an employer that lets an employee go because they have to pay severance. Sure. But we're going to talk about some situations where it's going to cost the employer that much more than the usual severance. Things that the employer, they're cost conscious may want to avoid, and obviously if you're an employee in that situation, you have rights and entitlements. So as you said, the first one we'll talk about is if an employee is fired because they're on a disability or maybe on a disability leave. You cannot let someone go because of a disability. cannot. That's a human rights violation. The company may be frustrated with the employee not being there, or the company may want to part ways because the employee's been gone for a while on a disability leave. Doesn't matter. You can't do it. It's illegal. And if the company does let the person go, and by the way, it doesn't even have to be letting them go. If they penalize them in any way, that's a human rights violation. So beyond the severance that the employer is going to have to pay, they're going to have to pay human rights damages. An employer has to accommodate, an employer has to allow the employee to get better and come back to work when they're ready. And if they don't do that, it's going to cost them.
We're talking about situations where employers can be in some, well, pretty deep water. Another one is if the employee demands payment for outstanding vacation pay, overtime, or holiday pay, stuff like that.
If you're an employee and you're trying to enforce your rights, you believe you didn't get paid your overtime, your vacation pay, your statutory holiday pay, and you want to get that, you're asking for it, maybe even demanding it, you cannot and should not under any circumstances be punished for that. You have a right to pursue your rights. And if an employer punishes you, well, you're the squeaky wheel, so we're going to let you go because of it. No, you cannot do that. That's a reprisal, which means it's going to cost the employer additional damage for doing that. Our entire legal system is based on the fact that employees have a right to pursue their entitlements. Now, you may be wrong. You may not be owed overtime. You may have gotten it wrong. But the fact that you're wrong doesn't mean that you're not allowed to pursue it, and it doesn't mean that you can be punished for pursuing it. So an employer that penalizes an employee for pursuing their rights is wrong, is doing something illegal, and it's going to cost them.
1-855-821-5900 anytime to get a hold of Lior. By the way, if you want to make that phone call, you can. SeverancePayCalculator.com as well. We're talking about things that will get employers in hot water. This one's got a big red beacon on top of it, and we talk about this all the time. Big no-no. Employee either announces a pregnancy or comes back from maternity or /paternity leave.
Yeah, I mean, we really shouldn't have to talk about this, in 2018.
Yeah, right.
But the reality is we do have to, because these things happen. Cannot let someone go because they're on maternity leave, going to take maternity leave, coming back from maternity leave, asking about a maternity leave. Same thing applies to fathers, paternity leaves. And if you do that, that's a human rights violation. That's a violation of the Employment Standards Act. It can be a wrongful dismissal. It's wrong on many levels. Don't do it. An employee has a right to take the leave for the required period of time, can come back to the same job, same compensation. Company's not allowed to do anything, and if they do, it's going to cost them.
Don't mess with mama.
Or Papa.
Or Papa. Is it on the mug yet?
No, not yet.
Ryan? We'll get to that. We're talking about things that will cost an employer a lot of money. Number 4 is when the employee makes a harassment complaint. Can't touch them.
Can't touch them. Law is very clear. An employee has a right to be part of a harassment-free workplace, supportive, not poison environment. But what follows from that is an employee is allowed to make these harassment complaints, and they cannot be punished for making a harassment complaint. Not only can they not be punished, an employer has to investigate it. An employer has to take remedies to fix the problem, to get rid of the harassment. And the last thing an employer is allowed to do, never ever, is to punish someone for having the audacity of bringing forward a harassment complaint. It's illegal. It could be a violation of a number of statutes, and you better believe it's going to cost them.
And this also applies if your direct manager or supervisor is the one harassing, right?
Doesn't matter who it is. First of all, harassment itself, you could be constructively dismissed, could be a human rights violation. Yeah. But to me, it's even worse that you had you're brave enough to bring it up, to say, okay, I'm going to not take this. I'm going to bring this up to try to fix the problem, and you get punished for bringing that up. No, that's wrong. It's wrong morally. It's also wrong legally. It's going to definitely cost the employer.
If you're an employer and want to stay out of hot water, don't do these things. Next one on the list is going to cost you because of an employee's age. They get let go for that reason.
Can't let someone go because of their age. We're now with an aging population. A lot of employees now are working longer, 60s, 70s, even longer than that. And they have a right to do that. An employer cannot let someone go because of their age. Now, some employees may, in fact, slow down with age, not because they want to, because there may be physical issues. But an employer has to provide accommodation. Now, at some point, accommodation can be too difficult, and they don't have to accommodate. But in most cases, 98% of the cases, they have to provide accommodation. So you can let someone go because of their age. You have to accommodate limitations. If you let them go because of their age, that's a human rights violation. You'd have to pay enhanced severance because it's going to take an older employee longer to find a job potentially than a younger employee. So you better believe, John, that if you let someone go because of their age, yeah, it's going to cost you.
Can an employer inquire or say, you know, can I make the job easier for you? Because I notice you're starting to slow down a little bit. You're not quite as sharp as you used to be. They can't fire them, but can they help them out in that regard?
They can. I'd be
Or
very
make the first move?
I'd be very careful there. You
Right.
don't want to necessarily accuse someone of something. I would be very objective in terms of documenting deficiencies. You used to complete 50 projects a year. Now you're doing 20. Is there something going on? Can I help you with something? You know, something like that that's subjective, it's fine. But rather than say, yeah, you're getting kind of old there. What do you want to do about that?
Long in the tooth.
Yeah, no, you don't want to do that. You got to be very careful. But yeah, an employer can and should be proactive if they observe an issue that needs to be addressed. You can't ignore it. That's probably good practice.
Help at employmentlawyer.ca is the email anytime to get a hold of Lior, 1-855-821-5900. We're going to finish off our points here, and this is it's going to cost an employer if they let go of an employee that they recruited away from another company.
Yeah, if you recruit an employee from another company and let them go, you're going to have to pay enhanced severance. You're going to have to pay severance that accounts for the time they had with the previous company. So you may have an employee that you just hired and you let them go after 6 months, but they were with the previous company for 10 years.
Right.
But you recruited them away from that company. Now when you have to pay them severance, you may have to account for those 10 years, even though they've only worked for you for 6 months. So an employer that recruits an employee and then lets them go, let's say in the first 2 or 3 years, is going to have to pay enhanced severance, which could be several times more than their regular severance. So it's definitely going to cost the employer. And for employees, you want to be very careful. If you're going to leave a secure job to join another company, you don't want to sign an agreement or other document that limits your future severance, or that even puts you on probation. Why leave a secure job just to be on a probation on another job? So be mindful of that, but certainly it's going to cost an employer that lets an employee go after recruiting them.
I was going to ask you, can the employer, the new employer, write that into a contract where they don't recognize past to save themselves some dollars if it ever comes down the pipe?
Absolutely. A smart employer that recruits an employee would specifically say in the employment agreement, just to be sure, employee, we're not recognizing your service with the previous company for any purpose. You should be doing that. Again, if you're an employee, you don't want to agree to that. So depending on your perspective, employee or employer, that employment agreement is extremely important.
1-855-821-5900 and help at employmentlawyer.ca. We're going to talk about the severance pay calculator and as well performance improvement plans after a short break right here on Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. John Scholes, Lior Samfiru. We're going to talk about a tool we love to talk about every week, and over 500,000 people have used this. It's called the Severance Pay Calculator. As I just finished the sentence, you can go to it, check it out. Absolutely free. It takes about 30 seconds, but I want you to expand on it.
SeverancePayCalculator.com, and the idea came to me over 5 years ago, 5.5 years ago, because so many people were accepting severance offers that were inadequate, and by the time they came to speak to me, it may have been too late. They would have already accepted it, and I was left with having to give them the bad news that I can't help you. So I wanted to do something to try to get to people, to get them the information when they really need it. When, Friday at 5 when they're let go and they can't reach me at that point, they need to have that information. So I created SeverancePayCalculator.com. Again, because I wanted to give people the access to the information, it's free. It's anonymous. There's no strings attached. All you do is you go to SeverancePayCalculator.com and you find out how much you are owed by answering 3 questions. That's it. It takes seconds, it's easy to use, and it's valuable information. And it's information you need because of all these misconceptions out there. Because so many people think that there's this silly rule of a week's severance per year of service or 2 weeks per year of service. Wrong. It doesn't exist. You're owed much more than that. So if you haven't used the Severance Pay Calculator, check it out right now at SeverancePayCalculator.com. And maybe you haven't lost your job. Maybe you're feeling good about your job, but you should still have that information just in case. And if you think in your mind, I know I'll get 2 months severance, 6 months severance, I bet you're wrong. Take the test, Go to severancepaycalculator.com right now. Find out how much you're owed. And if you know someone, you're talking to your next door neighbor, they're telling you, Friday was a bad day, they just let me go. Be a good friend, be a good neighbor. Tell them to check out severancepaycalculator.com.
You know, we'll take it for a spin. I'll give you an example and you can expand on it. After 22 years at the same company, Chris worked his way up from a casual part-time position to middle management, earning about $84,000 a year. Despite years of hard work, he was fired yesterday. Chris's boss simply said, "You had a good run," before handing him his exit papers, the cardboard box. His severance offer was 22 weeks pay with a 3-day signing deadline. Should he sign that offer?
Well, this is the classic week per year that people believe. And this is a good case because it demonstrates just how far off that is. So the main factors that go into assessing how much someone is owed is age, position, and length of employment. The longer you work, the older you are, and the more senior a position you have, the more you're owed. And that's what the severance pay calculator does. It assesses those factors and tells you how much you're owed. So let's plug that into the severance pay calculator. So using a middle management position, 22 years of service, 49 years old, and he was offered generously, 22 weeks pay. Well, severance, which is 5 months. Severance pay calculator correctly assesses him as being owed 18 to 24 months pay. You can see that on the screen right now. 18 to 24 months pay, John. The difference there at his compensation level is right around $100,000. Okay, and this is a real case.
Yeah,
you didn't make up facts here. I didn't make up facts. This is a case that came through my door days ago, which is why I wanted to mention this here. So if you believe that you'll get a week's pay per year of service, if he believed that, he'd be about $100,000 off here. So that's why. Hopefully this makes the point as to why you got to check out severancepaycalculator.com. First place, the very first place you go to when you lose your job. You grab your phone, you grab your laptop, check it out.
You think about the difference, though. It's over a year in pay. Not only pay, it could be a year in car allowance, a year in benefits, over a year of vacation pay, bonuses. All that stuff could be included or is included.
Included, yeah. So the employer may say, we're going to give you, in this case, 22 weeks, but just salary. But then the question becomes, well, wait a second. First of all, 22 weeks is terrible. But what about my bonus? Yep. What about my car allowance? What about my pension, my benefits? All those things have to be included. So remember, you cannot, should not, under any circumstances, I don't care what you think of it, cannot accept your company's severance offer without calling me, without going to the severance pay calculator. You don't like me, go to another employment lawyer. That's fine. That's how strongly I believe that you have to get advice if you lose your job.
EmploymentHourTV.ca is the resource you want to go to find a station, a radio station somewhere you can listen to our show. There's lots of them. We're all over the place. We do a ton of phone calls, as I mentioned in the first segment on the show. We'll get to another call, Lior. I know you want to comment on it.
Just wondering about salespeople that are commission and salary. Our current employer keeps bringing up coaching plans if you don't hit the target 2 months in a row, where they look to put you on a performance enhancement plan and then terminate you. Is that something that they can do or would not give you severance?
This is a question I get very often. Can I be let go for cause without severance because of what company says is bad performance? Can bad performance lead to cause? Well, for bad performance to lead to cause, in other words, to be let go without severance, the company essentially would have to show is that you're going out of your way to doing a bad job, that essentially that you're doing it on purpose.
You're sabotaging.
You're sabotaging it. Yeah. Maybe at least you're slacking off on purpose. You're not showing up to work. You're not doing your sales calls, whatever it is. But if you're doing your job as the best you can, but you can't meet those targets, you absolutely cannot be let go for cause. If the company wants to let you go, they'd have to pay your full severance. So with this particular call that we got, unless the company can show that he really screwed up, that he could have easily done a better job, but on purpose he decided not to do a better job, then they would have to pay him severance. It doesn't matter if they put him on a performance improvement plan. To be able to allege cause is extremely difficult. It's the death penalty. It's reserved for the worst offenders. So it's rare, and I want our viewers to understand this right now. It's extremely rare to be able to be let go for cause because of performance issues. Cause generally is reserved for misconduct. So if you're just bad performance, but you're not really screwing up, so to speak, it's just you're doing your best, but it's not getting where it needs to be, you cannot be let go for cause.
1-855-821-5900 and help@employmentlawyer.ca is the email. We're going to take a short break. When we come back from the break, we're going to talk sick day threats and the legality of temporary layoffs as well. Lots more Employment Hour in 30 is coming up.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And back with more Employment Hour in 30. I'm John Scholes. He is Lior Samfiru. Our radio show happens all over Southern Ontario. EmploymentHourTV.ca. You want to find a station where you can listen to it. You can call in during those shows as well. And we'd like to play the calls back and get some opinion from you, not from me. I just listen because I
Absolutely.
Yeah. So we'll do another phone call right now.
I was terminated from a job in 2016. I was with the company for 9 years. They gave me 2 weeks a year. I signed nothing. The one little catch here where it made a difference is 3 months before letting me go, what happened is they cut the hours down from 30 hours a week to 17 hours a week. And I understand I've got 2 years before I could put in a claim. Is that correct?
Remember that call?
Yeah, I remember that call as well. So let's start with the last question. He has 2 years to pursue the matter. That's absolutely right. So if you lose your job, you have 2 years to pursue your entitlements, which is why those deadlines are meaningless. Okay, those deadlines are completely ridiculous. They don't mean anything. It's a pressure tactic. So he's absolutely right. Now, by the way, I don't recommend waiting 2 years, but you have that if you need it. Now, his question is about his severance. First of all, because the company reduced his pay a few months before they let him go, the unfortunate part is now when it comes time to pay him severance, they have to calculate that severance based on the reduced pay, based on what they were paying him at the time of termination. So that's why it's so important to understand if the company reduces your pay, that's another reason why you may want to treat that as a constructive dismissal. Because if you accept that reduction in pay and a couple months later they let you go, you're now losing out on your severance as well, because your severance is calculated based on that reduced pay. So that's why constructive dismissal is important. But let's get to the real heart of his question. He was working there for 9 years. They offered him 18 weeks pay. Again, 2 weeks per year. A lot of people think, hey, 2 weeks.
Standard. They think.
Standard, maybe it's even good. Well, it's wrong. It's not even close. I can tell you how much he's owed. You probably can do that now as well because you've been doing the show with me for a long time. But let's plug that into the Severance Pay Calculator just so that our viewers can see how they can do that themselves. So he's in a professional position, 9 years of service. I picked an age, let's say he's in his 60s, and he was offered 18 weeks. Severance Calculator correctly assesses him as owed 14 to 16 months pay. Depending on how much he's earning, that's going to be a big matzo ball there. It's a big difference.
You bet.
So 14 to 16 months, not 18 weeks. That's why it's so important to get advice. That's why he called me and I connected with him and we're working to get him that severance. So it's not 2 weeks per year. If that doesn't demonstrate it, I don't know what will, John.
Final thoughts for today as we're about to wrap it up. A lot of good stuff.
A lot of good stuff. And you know, really the main thought I want our viewers to understand is that you have rights. When it comes to employment law, it's one area of law where, you know, whoever created the laws did a good job.
Right.
We have good laws for employees. We have a lot of entitlements that employees have. A lot of people, the problem is they don't know what those laws are. They don't know what those entitlements are. Well, we're uncovering those right here on this show, on our radio show. I do that in my office as well. So remember, there's problems, there's solutions, there's rights, there's entitlements. Company can't do whatever it wants. An employer does have obligations. Call me if you have questions. Go to the SeverancePayCalculator.com. Easy to get a hold of me.
Again, SeverancePayCalculator.com. Can't stress this one enough. If you wanted to pay for it, you can't. It's absolutely free. There's a contact button on the bottom of it. There's also an employer mode. If you're an employer, you can use it as well. It takes about 30 seconds to find the information that you're going to need even before you make that phone call. SeverancePayCalculator.com. The number as we wrap up for another morning, 1-855-821-5900. And finally, the email, always have it, help@employmentlawyer.ca as well. Till we do it again, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.